Prof, you muted.
It is now 4 o'clock, and it is my pleasure to start our event. It is not only my pleasure, it is my great honor to be the moderator for this particular session. And it is indeed a pleasure to welcome you all, colleagues, friends, ladies and gentlemen. In welcoming you, I think perhaps a quick recap as to the project for this afternoon. We are on the second part of a two-part series which started last week with the first webinar. This second follows upon that one, and the idea is to give space to talk, to reflect, to think, to even debate about a singular event of recent occurrence, which was, of course, the High Court judgment in the case of KSAC and others versus Ingonyama Trust and others. It is a judgment that has instilled a lot of hope in a lot of people. It is a judgment that anybody who was lucky enough, I guess, or privileged enough to have something to do with the process is very, very proud of. We do know there are dark clouds hanging over it in the sense that there is some recalcitrance on the part of some leadership in the board to attempt an appeal which, fingers crossed, we hope will not come to pass. But having said that, my duty, pleasant duty, is also to be able to introduce the panel that we have this afternoon. This is composed of former President Kgalema Motlanthe, who will be addressing us or sharing his thoughts on the topic of reflections of the high-level panel process and recommendations in light of this case. I should say, as an aside, that one of my most pleasant and privileged activities in the last 3-4 years was when I had the good fortune with others to participate in the high-level panel that was led by the Honorable former President, and that is what he will be talking about. The next speaker after former President Motlanthe will be Zenandi Boy, who is the team lead or the lead researcher of the land team in LARC, which of course is the host of this event. Zenandi will be talking on the implications of the judgment in relation to the 2018 landmark judgments of Malada, if you recall, and Mbaleni. And the question really will be, how did the Ingonyama judgment flesh out and elaborate on the key earlier protections by reference to customary law and decision-making requirements? What are the implications of the findings made against the minister in particular for rights holders in KZN and in the rest of South Africa? Finally, our panel is going to be, or has on it, who will address us, Bulelwa Mabasa. Bulelwa will be reflecting on the judgment in respect of the tenure gaps highlighted by the facts that led up to the Ingonyama Trust Lease Case, and tie this to the findings and conclusions of her book, Land in South Africa, Contested Meanings and Nation Formation. Because we did say that I would want to cluster everything in this introductory bit so that I can then disappear from the scene and let the process for this afternoon roll on seamlessly until we come back for question and answer. I am now going to read the introductory resumes and CVs of our panelists. I say read because worrying that I will tend to ramble, as I am sometimes known to do, I have written them down. They have been prepared to control that eventuality. We start off with that of our former President Kgalema Motlanthe, which is that while working for the Johannesburg City Council in the 1970s, Kgalema Motlanthe was recruited into Umkhonto weSizwe, MK, at the time. After 11 months, detention in John Foster Square, a police station in Johannesburg, he was sentenced to an effective 10 years imprisonment in 1977, which he served on Robben Island. After his release in 1987, he was tasked with strengthening the trade union movement while working for the National Union of Mine Workers, NUM. In 1992, he was elected as NUM General Secretary, was involved in the establishment of the Mine Workers Investment Company, the Mine Workers Development Agency, and the J.B. Marks Education Fund, which focused on the developmental needs of ex-mine workers, their dependents, and communities. Served 2 5-year terms as Secretary General of the ANC, was the President of South Africa from September 2008 to May 2009. During this time, he battled with the financial crisis of the time, joining world leaders in the G20 and other multilateral bodies to respond to this crisis at home and abroad. After the end of his presidency, he was appointed Deputy President and held this position until May 2014. Kgalema Motlanthe now heads the Kgalema Motlanthe Foundation, which was established when he left government. I will go on now to read the introductory biography of Bulelwa Mabasa, who is the director and head of the Land Reform, Restitution and Tenure Practice at Werksmans Attorneys. Bulelwa, you will forgive me, I have worked hard to decide whether the place of employment you come from is to be pronounced in Dutch or in an English sounding accent. Worksmans or Werksmans. But Bulelwa has been around in this area for a long time. Her expertise is spread across a number of practice areas. They include dispute resolution, infrastructure, energy and projects, and mining and resources practice areas. Education, BA from the University of the Witwatersrand, as well as an LLB from the University of Witwatersrand, plus a number of postgraduate qualifications, and a career that has led to highlights which include am I on? Highlights which include an award for Best Woman Lawyer in Land Rights at the Women in Law WOZA Awards ceremony during August 2019. She has also been appointed by the current president in the Land Advisory Panel. Bulelwa, we are very happy to have you as part of this illustrious channel. Finally, I say finally, that is simply chronologically, but also because as the hosts, LARC, I am introducing the LARC, our LARC member last, but definitely not least, Zenande. Zenande has been with LARC for a while. We are very thrilled to have her with LARC as our member, Zenande boy. She currently is the lead researcher at the Land and Accountability Research Center, lead researcher in the land team that comes with a cluster of responsibilities and functions that make her, like many of us, very keen to dig deeper into the judgment we are here about, as it was about, seriously about some of the matters that LARC is involved in relation to land rights. She has, Zenande, an LLB from the University of Cape Town, Master of Laws in International Legal Studies from Georgetown University in the US. Zenande, I was actually quite thrilled with this because when I read it, I hadn't known it, and it's something in my young days I aspired to, was a clerk for a constitutional court judge. If you were to rewind the clock and give me time, I'd like to do that as well. She clerked for Deputy Chief Justice Dikgang Moseneke. Ladies and gentlemen, that is our panel for the afternoon. And President Kgalema Motlanthe, I think we're ahead of time, but it seems to me that there is no time, better time than now. Let us start. And there will be 15 minutes given to each presentation. Thank you. Please, over to you.
Rose, your mic is on mute. It's still on mute. Yeah, there we go. It went off again.
Yeah, okay.
That's good. It went off again.
Ja, oké.
Perfect. Daar gaat het weer af. Okay, it's on mute again. What's happening?
Can you hear me now? Oh.
Yes.
Yeah.
You may proceed.
Yeah, I don't know. I think the censorship board is trying to censor me. And anyway, thank you very much, Prof, for affording me the opportunity to share some reflections on the work of the high-level panel on the assessment of key legislation and acceleration of fundamental change, which was established by the Speakers Forum and in December of 2015, and with a mandate to assess impact of legislation passed since 1994, with focus on 3 thematic areas, namely the first thematic area was on poverty, unemployment, and equitable distribution of wealth, and the second was on land reform, redistribution, restitution, and security of tenure. And the third area of focus was nation building and social cohesion. And the first step that panel followed was to put together a compendium of all key laws passed from 1994 to 2015. And having done that, one of the pieces of legislation that the panel had to deal with, which is of relevance to our webinar today, is the KwaZulu-Natal Ingonyama Trust Act number 3, case Z of 1994, which was piloted through the KwaZulu legislature, and the law went through 3 readings in one session, and came into force, having been ascended to by the president, then president of South Africa, F.W. de Klerk. So it came into force on the 24th of April 1994. So you will realize that there was a link between the passage of this law and the peace deal that was entered into, purportedly brokered by some international mediation. However, the detail of what really transpired and led to the formation of the Ngonyama Trust Act and influenced the decision of the IFP to joined South Africa's 1994 elections. That the detail of that is contained in it's covered in an article by Hilary Lind, and it's published in the South African Historical Journal. The Ngonyama Trust Act was put together with the of protecting the rights and benefits and the material welfare and social well-being of members of the tribes and communities living on the land, which was formerly KwaZulu homeland. This act was later amended in 1997 to create the Ngonyama Trust Board, which administers the land. As a panel, the high-level panel held a number of roundtable discussions with experts, commissioned research on the land question from a number of research groups, and most important of all, crisscrossed the length and breadth of the country, virtually affording South Africans in all the provinces to share with the panel their lived experiences under the various laws that the panel was interested in. And in the course of that 21 months, the panel spent 2 days listening to communities and residents of various jurisdictions, including the Ingonyama Trust Act. And in the course of those interactions, we spent a whole day with the chairman of the Ingonyama Trust Board, Mr. Jerome Ngwenya, accompanied by the then CEO of the board, Dr. Madlop. And from the testimonies of people living in the rural areas, it became clear that at some point the Ingonyama Trust Board decided to convert the permission to occupy certificates that people had and their customary rights in land into lease agreements for both business and residential purposes. The lease agreement was a document which you could apply to any gated community in the suburbs. The salient point, however, was that lessees were expected to pay rental from 1,600 per annum, and it escalated by 10% annually. And the lessees were also, according to the agreements, expected to fence off their area of residence within 6 months of entering into such agreement. No clear procedures were followed to explain to people what all this meant. I recall that some residents from Ejozini shared with us how they were simply invited into the center there, and they were advised to bring their IDs with them, and when they got there, they were then instructed to sign the agreements. And they were led to believe that they were joining the Ingonyama Trust, and only to discover later that they were to pay these rentals, and therefore were very aggrieved by how this was imposed on them. So the panel put this to the chair of the board, Mr. Ngwenya, and the CEO, and both denied that such agreements were being imposed on residents, and admitted that these only applied to businesses. So the panel formed the view that the board, acting on behalf of the trust, simply regarded itself as the outright owners of the land, and therefore not subject to any duty or obligation to consult or obtain community consent in dealing with the land that these communities occupied. Whereas the Ngonyama Trust Act also provide for protection for the land rights of the beneficiaries, in particular that the Ngonyama shall not infringe upon any existing rights or interests. So in spite of this provision in the Act itself, the board saw fit to basically convert people's PTOs, no regard to and customary rights, and imposed these agreements upon residents. And this basically proved the vulnerability of residents within the jurisdiction of the Ngonyama Trust to abuse of power by traditional leaders, even though there was no law or provision for such powers. They had no such legal powers to abuse in relation to land occupied by communities within their jurisdictions, and so the panel at the end, when after 21 months, when the report was being put together, took the view that this Ingonyama Trust Act is actually unconstitutional, and that so in the recommendation, the panel recommended that it should either be repealed or amended to bring it in line with the Constitution of the Republic. And so we believe that the judgment by DPJ Madondo vindicates the position that the panel had arrived at, and also clarifies the question of who the real owners are, because these people live in trust-held land, and they are the beneficiaries, and so the judgment helps to clarify that in fact they are the owners of the land they occupy, and I think the provisions of the Interim Protection of Informal Land Rights Act, IPILRA of 1996, are also reinforced by this judgment. Personally, I'm ashamed for myself that the Minister of Rural Development and Land Reform opposed the application of this rural women's movement and other applicants, because in that opposition, it actually exposes the fact that the portfolio committee in Parliament also failed in its duty to hold the minister accountable. The mere fact that the minister could oppose an application of this nature reveals and I think exposes the workings of the arms of our state, particularly Parliament on one hand and the executive on the other hand. And thanks to the judiciary, we are today glad that they could hand down such a judgment which not only clarifies the rights of people living in rural areas, and of course, as a high-level panel, over and above the recommendations relating to the Ngonyama Trust Act, the panel also felt that the rights, tenure rights of rural people living within the jurisdictions of traditional leaders should be secured in legislation, so as to protect them from such abuse. And the panel also covered the tenure rights of those who farm labor tenants, that their rights as well should be secured in legislation. Now, this has not happened in spite of the report having been submitted in November of 2017, where Parliament has not implemented the recommendations of the panel, and at the moment they are looking at Section 25 of the Constitution, which really does not impede any action on the part of the state to address land hunger. So, in a word, in a nutshell, the recommendations of the high-level panel in relation to the Ngonyama Trust Act have actually been reinforced by this judgment. Prof, let me pause there. Thank you very much for your kind attention.
Good afternoon, and thank you for watching today. I'm so excited to be a part of such an incredible collection of panelists, and thank you to Professor Nhlapho for facilitating today. My contribution today will focus on the trajectory of recent judgments that have had massive implications for tenure security in the former homelands in terms of making clear the constitutional protections that these rights are entitled to. Today, I will firstly be dealing with the unanimous Constitutional Court judgment in Malada versus Bakatla Mineral Resources. Second is the Baleni versus Minister of Mineral Resources. And finally, at the center of recent discussions, KSAC versus the Ingonyama Trust Board. While I go through these judgments, I want us all to keep in mind a point that was raised by Dr. Siyabo Manona in last week's discussion. He highlighted that legal judgments of this nature inherently have a limited role in affecting systematic change. Part of the problem emanates from the nature of how court systems function. This is a reality that remains at the forefront of our minds for most of us who work in this context. Courts are by their very nature inaccessible to a majority of South Africans, particularly poor communities that continue to bear the brunt of tenure insecurity in a post-democratic South Africa. While it is important to take time to appreciate these victories, we must at the same time be developing and devising innovative and responsive ways in which to ensure that these victories result in real and tangible improvements for people's lives. As mentioned above, I will start dealing with the Malada judgment to start us off. The facts of the Malada judgment are illustrative of the continued impact of racist laws, practices, and policies that were aimed at ensuring Black people were not able to own their land and control what happens on it. In this case, in 1919, after 4 years of raising money through contributions, 13 families who were members of the Bakatla community came together and bought the land in question. But because of the 6 native rule that applied then, where if more than 6 Black people intended to buy land, they were required to affiliate with a tribe that was recognized by the government, and then that land would have to be vested in the government on behalf of that tribe. It was not possible to have it registered in the name of the actual purchasers. As a result, the land in question that belonged to the 13 families in this case was vested in the government on behalf of the Bakatla Bakafela, with nothing to reflect the true purchasers of the land. And when we fast forward 100 years, a mining right is then awarded over the land without properly consulting the descendants of the actual purchasers of the land. And when the owners of the land refuse to just let mining happen, the mining company goes to court to get them evicted and to ask for an order barring them from access to their land. The community relied on their rights held in terms of the Interim Protection of Informal Land Rights Act, saying that the mining company had failed to obtain their consent to be deprived of the rights that they hold in terms of Apelra over their land. The community was one of few communities that were able to access courts in this instance. The narrow question that the Constitutional Court dealt with was whether it was allowed for a mining company to simply apply to evict people from their land and bar them from entering that land without first using the remedies provided in the Mineral and Petroleum Resources Development Act and properly extinguishing prior existing rights to land where a mining right was awarded. What's important to note in this case is that this case was between mining companies and the community that owned the land. The Constitutional Court did not deal with whether the mining right was valid. It focused on what the obligations of a mining company were when a mining right was awarded to it in terms of IPELRA and the MPRDA. Another important thing is in this case is that it was litigated in a context where the Department of Mineral Resources and holders of mining rights were very secure in the fact that the MPRDA basically trumped all laws that might conflict with it being able to operate unimpeded. The mining company argued that it could exercise its mining right and that it was not bound by a PILRA and that there was no obligation on it for it to obtain the consent of directly affected rights holders before exercising its mining right. Because of our history of ignoring and weakening rights to land held in terms of customary law, the exclusion of Black people and the exclusion of Black people from being able to hold rights to land in terms of common law ownership and to benefit from the protections that those rights have. This interpretation of MPILRA and the MPRDA in terms of its relationship would leave communities who historically and currently have vulnerable rights to land with absolutely no protection if it was said that the MPRDA completely trumped and then erased rights held in terms of MPILRA. The court considered, amongst other things, the complementary aims of both MPILRA and the MPRDA, which are both to achieve land reform. In that context, it found that the rights that people held in terms of MPILRA, as well as the rights being granted by the DMR in terms of the MPRDA to mine, could coexist, therefore making it that the MPRDA could not trump MPILRA and does not automatically erase rights held to land in terms of MPILRA. The court found that when a mining right holder uses its mining rights by attempting to or beginning mining operations, this amounts to a deprivation of the rights holders of MPILRA rights and that their consent is needed before mining can continue. The court held that an appropriate process to lawfully deprive people who hold rights in terms of MPILRA exists in the MPRDA in terms of Section 54. The section deals with the determination of compensation by agreement between parties through either a court order or agreement between them, and that in the case of people who hold rights in terms of MPILRA, those rights can only be lawfully given up or deprived of by obtaining the consent of the directly affected rights holders. This court's findings in this context were very important in restoring and highlighting as a constitutional imperative the protection of these rights that had historically and are currently incredibly vulnerable to unlawful dispossession. When we move on to the Baleni judgment, the Baleni case was a case brought by the Xolobeni community in the Eastern Cape against the Minister of Mineral Resources and dealt with the question of whether consent would be required before the DMR could award a mining right over land where people held rights to land in terms of MPILRA. The judgment rightly listens to and relies on the Xolobeni community's account about the important relationship between traditional communities and their land. It earnestly tries to begin to illustrate how for communities like Xolobeni, who have lived on and fought for their land for generations, the importance of land is at the center of people's livelihood, identity, culture, traditions, customs, socio-economic, and ecological fabric. However, the DMR, as well as the mining company in this context, refused to accept that customary and MPILRA rights holders had a right to consent to mining before a mining right was awarded. They stated that the MPRDA explicitly does away with the consent requirement of common law owners, and therefore, even though the MPRDA does not explicitly deal with customary law, the same exclusion should automatically apply to customary law as well. They argued that the Constitution requires common law and customary law to be treated the same. Otherwise, they argued, this would mean customary law ownership will be getting special protection in the MPRDA that common law ownership does not. This argument was rejected. It was made clear that what the Constitution does is place customary law and common law on an equal footing in our legal system, making both laws subject to the Constitution and constitutional legislation that specifically deals with them. Customary law is no longer subject to common law for its validity. But being equal does not mean that these laws must be treated the same, or that the statutes that regulate common law automatically regulate or change customary law in the same way without having to specifically regulate customary law. The MPRDA says nothing about customary law when it nullifies the consent requirement in relation to mining. It can't be assumed that it does. The court also said that the Constitution is well aware of the continued impact of our history on the current vulnerabilities faced by rights held in terms of customary law. A huge aim of the Constitution is to remedy the continued impact of historical injustices. Therefore, it is very much within the purview of the Constitution and the MPRDA that these rights held in terms of customary law and the Interim Protection of Informal Land Rights Act are given greater protections. Like in the court in Malada, Judge Basson in the Baleni case found that the MPRDA does not trump appellra, that the consent of the directly affected rights holders of appellra rights must be obtained, that the directly affected holders of appellra rights consent must be obtained before a mining right is granted over their land. What is important about this judgment as well is that it also sets out how to appropriately obtain consent in terms of appellra, and it sets out what is necessary to ensure that that consent is valid. In terms of how to obtain consent, appellra provides that where land is held on a communal basis, for it to be deprived properly, then the consent of the community needs to be obtained in terms of their customary law. At the very least, if customary law has no other provisions, at the very least, a meeting specifically about obtaining consent must be convened, proper notice given, and that the majority of the directly affected rights holders in attendance must agree to deprivation. However, the community in Xolobeni made it clear, and the court accepted, that what is set out in appellra is just the floor of possible protection. Customary law can require more for consent to be validly given by a community. In the case of their community, they stated that majority agreement would not be enough. To minimize conflict, protect vulnerable people and their way of life, the customary law in Xolobeni required that there be consensus and not just majority agreement for the consent to be valid. Another aspect of the judgment also looked at how do you ensure that the consent obtained in terms of appellra is valid. The court went into a lot of detail about the need for the principles of free, prior, and informed consent to be complied with, as it is required in terms of South Africa's international law. In terms of free, prior, and informed consent, the consent must be given freely and that it can be refused if the community does not want it to happen. It must happen before any decisions or actions that would deprive the community of their rights are done, and they need to be informed. And this means that all the information that's necessary to ensure that a decision is made is provided and made available to the community in a way that it can understand. So what you're seeing from these previous judgments, is a growing and rich jurisprudence that is beginning to flesh out the important constitutional protections that these rights need in the face of consistent threats of dispossession. What Deputy Judge President Madondo eloquently begins to do in his judgment when he declares the leases program that was implemented by the Ngonyama Trust unconstitutional is to really begin to engage in the important work of starting to articulate the strength, the nature and content of customary law ownership rights to land. The other two judgments weren't able to do so because of the facts and the questions before that court. This case was brought by KSAC, the Royal Women's Movement, and several community members that had been unlawfully induced to converting their customary law ownership property rights to leases with the Ingonyama Trust. Rural community members were made to conclude onerous leases with the trust, weakening customary ownership and PTO rights and reducing owners to rent-paying tenants of the trust under the threat of not being recognized as forming part of their community or even part of the Zulu nation. This land was vested in the king, and the very clear obligations that limit the ability of the trust as well as the trustee to engage with the land is to ensure that this land is vested in the trust solely for the benefit, material welfare, social well-being of the members of the tribes and communities that live on that land. Further limitations on the trust and the trustee being able to make decisions on this land is that they must ensure that this land is administered in terms of Zulu customary law and that no pre-existing rights can be infringed upon it by any administration processes that are put in place. So Judge Madondo painstakingly went through a process of illustrating the difference between customary ownership rights, PTO rights, and leases to show the absurdity of the trust's claim that it was upgrading or reinforcing PTO and customary ownership rights by converting them to leases. The leases people were being made to sign were for 40 years, vested in only one person essentially raising all other rights and other rights holders in that land, and it could not be inherited. Rent had to be paid and increased every year, and the trust could unilaterally cancel the lease for breach, and a breach could include a failure to pay rent. When Judge Madondo started engaging with how land is actually administered in terms of Zulu customary law, Judge Madondo distinguished between residential, arable land that is allocated to individuals and families in terms of customary law, and communally held land, such as grazing land that communities hold for the benefit of community members that are a part of that community. Judge Madondo made it clear that people who have residential and arable land in terms of customary law are owners. Their holding of that land is sacrosanct. It is inviolable and passes from generation to generation. It is the property of that family. Exclusive rights are given over these residential and arable plots. This land is owned in terms of customary law. This ownership is protected by the Constitution, the Interim Protection of Informal Land Rights Act, as well as the Ngonyama Trust Act itself. In important respects, common law ownership, customary ownership has all the necessary components of rights that make up ownership. When summarized, the components of rights that make up ownership tend to be the capacity to possess, the capacity to use, enjoy, alienate, and destroy a thing. All these components of rights exist in customary ownership rights. Possession being the ability to control a thing for one's own benefit. The right to use and enjoy means the capacity to use the land and entitles the owner to the enjoyment of the property as well as the fruits that derive from it. The right to alienate property is also an element of ownership. Being able to alienate land, however, is not just limited to being able to transfer land freely and completely to another person, as you will see in freehold common law ownership. It also includes being able to dispose of land in other ways. A customary law landowner is also able to exercise all these above rights to ownership to the exclusion of other members of the community, and this includes the right to alienate that land. He can transfer that land in another person in the community, even an outsider who might remain a member of that community. So the definition of being able to alienate that right might be more limited than in the common law context, but it is not any less valid. Judge Madondo found that the trust had violated its obligations in terms of the Constitution, the Trust Act, Zulu customary law, and appealed by depriving residents of their ownership rights and making them tenants on land that they own. Judge Madondo's articulation of the ownership, customary ownership in relation to people's residential and arable land in terms of customary law is an important addition to this growing jurisprudence, fleshing out protections to previously ignored and unprotected land rights. These rights are valid and strong property rights that the trust and the minister have a positive obligation to protect and to give effect to in terms of the Constitution. Thank you. So I'm going to be handing over to Sis Bulelwa, and I look forward to the questions.
Thank you very much, former President Motlanthe and Zenande, for very illuminating discussions. I think it would be improper of us to delve into an issue of such a public interest if we were not to pause for a moment to recognize the mood and the tension in the country, and particularly in the KZN province, as I delve into the takeaways of the that flow from the full bench decision of Judge Madondo in the Ingonyama Trust matter, which Zenande has just summarized. I think the second theme that I would like to bring forward is that, you know, as people in academia or the formal sector or NGOs and activists, it is important that as we have these discussions, that these discussions have a flow through and an impactful and tangible meaning for the people that these judgments ought to, and the lives that these judgments that flow from court ought to impact. And thirdly, just as an introduction factor, is to recognize and acknowledge the spirits of Umam Sizani Ngubane, who was fiercely instrumental in her work with the rural women's movement in putting to the fore the issues that were particularly faced by women in the KZN area. I recall, as part of the work that we did as the Presidential Advisory Panel on Land Reform that was appointed by President Ramaphosa, you know, halls full in the UKZN University of elderly women who lamented the fact that their rights to tenure were trampled on, and it had to depend on whether a woman is married to a man, has a boy child, or has a brother in order to access these land rights. So it is within that context that I'd like to preface this discussion and to really bring to the fore how the judgment of Judge Madondo impacts on policymaking and the future of tenure in South Africa. So as Zenanda correctly pointed out, I'm going to just summarize the basis of the full bench decision of the KZN decision in the Ingonyama Trust judgment, or the KSEC judgment. The Ingonyama Trust board and the trust was found that they couldn't conclude lease agreements with persons living on trust land who are the beneficial owners of the trust, and that the trust had to, I think importantly, refund all the monies that were paid unlawfully by the inhabitants of the Ingonyama Trust land. And I think it's important to also point out that the minister was found to have breached her duty to protect, to promote and fulfill the constitutional rights of property holders, of IPILRA holders. And my topic really is to identify where are the gaps, what are the opportunities for the future in policy making. And I think paragraph 5 of the court order is instructive. And it says that until such time that the minister may implement an alternative of system of recording customary and informal rights to land, she must report to the courts on steps that need to be taken in order to comply and to build an administrative capacity to implement a PTO regime. What does this tell us? This tells us that more and more courts are finding themselves in a position where they have to institute structural interdicts because of the failure of Parliament and the executive in elevating and protecting these rights, especially Section 25 rights to land reform. We found a similar situation with a constitutional court decision on the day that Judge Cameron retired from the Constitutional Court, which judgment was the judgments that forced the Department of Land Affairs to create an infrastructure to enable labor tenants rights to be administered and to provide an infrastructure. So we're finding ourselves currently in South Africa where the judiciary more and more has had to enter the space of Parliament and in other cases of the executive in order to achieve substantial justice for our people. The comment that I'd also like to make is that, I mean, in this judgment, that the court's hands were tied in that the system of PTOs emanates from provincial legislation in the form of the KwaZulu-Natal Land Affairs Act, in circumstances where really land reform is a national competency. In other words, in terms of the Constitution, it is the national government that ought to ensure that we have a system of tenure that is legally recognized, that is registrable across the country. So I'd like to pause and say, obviously, the Ingonyama Trust judgment is a standalone and is a bit of is nuanced because it has a specific political history attached to it. But I think this is an opportune moment for us to pause and say, what does it mean for the rest of the country? We understand that it came as a result that the trust itself has a peculiar political history, but what can we take from this judgment that can find application and relevance in the rest of the country? In doing so, I would like to just quote, and perhaps not necessarily quote, but just to set out a few of the themes that emanate from Mistra's publication, which I co-authored with Kwezi Mabasa, that touched on various themes that I find relevance and importance in this discussion on the future of tenure in South Africa. The starting point, which is quite telling, is that 60% of all South Africans currently hold land or property outside of the recognized legally recognized system. So what did Parliament do? Or what was Parliament's idea on how this could be achieved? I think unwittingly, Parliament continued on the pre-colonial or on the colonial and apartheid thread of continuing with communal rights on one hand and freehold title on the other, where, for example, Black people residing in communal areas were beholden to a system that does not fall part of our recognized and formal legal system. And included in that are the Black urban people who also were not incorporated into a formal legal system that all of us, or most, or rather the minority of South Africans enjoy. So that's the first thing that should cause us to worry. What was Parliament's proposed solution for that? So when Parliament imposed, or rather introduced legislation such as Ultra in Ipilra, they placed the obligation on the very same people who were landless and dispossessed with land to take positive steps in upgrading their pieces of legislation, instead of finding ways in which their land holding could be incorporated within the formal property legal system that exists. Another stat that we need to be worried about is that 31 million South Africans fall outside of the formal legislated systems of tenure. I argue that Ipilra and Ultra were legislation that still exists, and of course the court could not have ignored that legislation, because ignoring that would mean that we would have a gap in the system. However, it does present an opportunity for Parliament to go back and introduce legislation that does not continue on this second grade rights that are that seem to be accruing, or that have accrued to the Black majority. I argue in chapter 2 of the book, Land in South Africa, Contested Meanings and Nation Formation, that current tenure systems continue to perpetuate the apartheid legislation. And my colleague, Professor Baynard and David Copland in their chapter point out that Parliament and the executive are still obsessed with the idea that Black land holding was always communal. And they take us through a journey to show us that pre-colonial systems, there were in fact rights to individual tenure that Black rural people enjoyed. For example, the idea that a household had aspects of individual tenure, and that not everything that is attached to ruralitarianism has to be communal. So we find ourselves in this situation because we have not disabused ourselves with the idea of seeing Black people or the Black majority as people that can hold land formally and to be recognized as people that can have family rights or even individual rights. And another theme that emanates from the publication, our book, is that land policy should be embedded on inclusive nationalism identities. And if that is our premise, then that would inform how we then choose to protect, regulate, and to recognize land rights of people that have remained largely landless. In my chapter, I delve into identifying certain pieces of legislation that continue to exist beyond the constitutional framework. And those pieces of legislation find expression in our historical roots of law and property laws that come from the Roman Dutch system. And so therefore the Constitution, and I think it's schedule 1 of the Constitution, has actually said to us that at the promulgation of the Constitution, work had to be done to say, yes, the Constitution has been promulgated. We have to go back and see what legislation continues to impede the developmental agenda in South Africa. Ngapai, in the chapter of the book that I'm talking about, Professor Ngapai, he speaks to the unchecked power of traditional authorities. And it is on this basis that I make the proposition that we have to take this KZN Ingonyama Trust judgment and find application to it across the country, because the unchecked power of traditional authorities and traditional leaders will continue to impede the interests and the rights of communities on land that they own. So he agitates for rural citizens to have full control over land. And this idea is then supported by the judgment of Judge Madondo and the rest of them. So what really we are, I mean, I could quote other themes and chapters that emanate from this publication that also agitates for active citizenry and for Parliament to take an intentional and directed stance at removing this dichotomous system of tenure that continues to treat citizens, whether they are Black urban citizens or Black rural citizens, as third-party citizens that have to go through other parties of interest in asserting their rights to land. So I think that this is a welcome judgment. It also proves the community engagements that we had gone through as part of the Presidential Land Reform Panel, that those citizens who resided in those areas had told us. So the evidence bears itself out. The Malada judgment and Baleni judgment that Zenande has spoken to are all useful tools that should now direct a direction and an effort by the executive, by Parliament, to start to revolutionize and reform tenure systems towards either a unified tenure system that all citizens of South Africa are able to enjoy, that can be traced in either a deeds registry, that can be recorded, that can be registered, or one that requires current amendments of current legislation where family rights could have the same protection, and so forth. So I think I will end it there and move over to Prof. Thank you.
Prof, you're on mute. Prof, you're on mute.
I am told I was muted. I hope I am now unmuted. I was saying thank you very much for 3 totally inspiring and insightful presentations. I notice that former President Kgalema Motlanthe seems to have left the meeting. We are, however, left with 2 of the members of this panel who are absolutely at home with these topics and who will be with us to answer some questions. And of course, as you know, you are also colleagues and friends free to pop your question in or your answer or your comment in support of any point of view that you have. I think I'd like to perhaps abuse a little the position of facilitator by asking the first question simply to get us off and the ball rolling. And this is particularly for our panelists, but anybody else who feels free to share, please do so. What I really want to know, and this is a layperson's question, the layperson in me says, however interested I am, and I really am, in the judgment, the benefits of the judgment, the hope, for me that's big because we were getting quite despondent at the behavior of the executive and the government and policymakers. So the hope that it has kindled, what are the chances of success of an appeal?
I can start.
Denzel, Zenandia.
Thank you very much, Prof. I mean, I don't think that there is much prospect of success in relation to any appeal that the trust might have to do. I mean, in sort of dealing with the arguments of the trust in favor of this power that it said that it had in being able to lease this land, the judge was quite extensive in his dealing of those arguments and sort of doing away with the arguments and explaining exactly why the trust cannot itself sort of be taking up these powers that it actually doesn't have in terms of the law. And I think in sort of setting out why the trust can't claim these powers, the court was really also great at starting to sort of really articulate what we mean in terms of the types of obligations institutions like this should have. So institutions that currently hold land on behalf of communities should be held to a particularly high standard to ensure that they're not abusing powers, that they're not exercising powers outside of what they're actually empowered to do in terms of the law, and that they're not benefiting at the expense of the people on behalf of whom they're supposed to be holding this land for. And the court was very sort of clear in illustrating in the judgment the extent to which this policy that the Ingonyama Trust says was aimed at trying to sort of strengthen people's land rights was patently not that. And the trust itself understands very much that like what they were doing wasn't improving and strengthening people's land, rights to land. And it became very clear, even looking at, the trust itself has said expressly that it needed money, and that this was really a form of revenue for it to be able to administer the land. And the trust was the court made it very clear that you can't, as a land holding institution for the benefit of people, then start using those people to get income to administer the land for them in a way that doesn't benefit them at all. So, it has tried to appeal, so it's indicated that it wants to appeal, but it's not very clear. It's very clear that it won't succeed because there's no basis on which they could rely to really illustrate that they do have the power to lease this land, and that if they do have the power to lease this land, that they were exercising that power in a way that actually benefited the people that live on that land. Because they're not able to answer that question of like what happened to the money. Where is the money right now? Thanks.
I think in addition to what Zenande has said, what is interesting for me is that the minister is now told or directed to create an administrative infrastructure to register PTOs. But that is only in relation to the KwaZulu-Natal Land Affairs Regulations and Act. And for me, that is interesting because, as I said, land reform is really a national competency. And I think the regulations originally empowered the MEC to register and to administer the PTOs. But I think it goes into the fact that land reform has been so bedeviled that the court is ending up having to make decisions to assert PTOs precisely because there's a gap. There is a gap in the national framework that provides a tenured legislative system that is not underpinned by communalism, that is not underpinned by traditional leadership, and which is why we have found, the Communal Land Rights Act in a state of flux for a long time, that was declared invalid by the Constitution. So I think whether or not there's very little scope, in my view, for the appeal succeeding, but I suspect that from the minister's point of view in relation to the KZN issue, that there could be some scope for her to argue that the KZN regulations themselves might be contrary to her national responsibilities as a national function as opposed to a provincial one. Yeah.
Well, thank you. Thank you very much for those answers. We have just enough time, I think, to go to some of the questions that have already been tabled. If we go to those, maybe let me read you the one from Rwanda. Some people living in KZN have mentioned that not everyone has been induced into signing leases. Therefore, these leases simply do not exist, and it's a political plot to take land away from the Amazulu. What are the panelists' thoughts on this narrative? Can I kick off with you first, Bulelwa?
That's an interesting question, because this is why I said that sometimes there are challenges where you have political issues that are required to be solved by the courts. When she says it's a ploy to take away land from Amazulu, we are sitting with an act which has not been declared invalid that made it possible for the land under the trust, to be held in trust on behalf of the people of Amazulu. For as long as that act remains valid and there isn't anything in court to invalidate the validity of that act itself, then you perpetuate arguments that are being thrown around to say land is being taken from, Abantu BaKwaZulu. So the reality of the matter, the reality is the fact that that was a political creation, which is unique to the KZN situation, that created the trust. And until there is a political situation a political solution to deal with that, we're going to be faced with court judgments that are made by the judiciary that are not capable of finding meaning and implementation on the ground, as we'll have seen as we see today, with court judgments that have emanated from the judiciary and people simply not, finding meaning to them. So, in a nutshell, my short answer is the judiciary can only deal with legal issues, but politics must be dealt by politics.
Okay, thank you. Zanande?
Just briefly, I mean, I completely agree with everything Spula was saying, but I think people are sort of missing the point of this judgment. If there was only one lease and one person whose tenure security rights were being put under threat by the trust, that's enough to have to go to court and prevent that, and to prevent it from spreading across. So I mean, technically, it is a really good thing that not everyone was induced to sign leases, because this was not a process that should have gone to the extent of everyone in KwaZulu-Natal signing leases with the trust. So if the point of this judgment was to prevent just that, the effect of these leases being to dispossess people of their rights to land. So then if only 4, 5, or 10 people were the ones that signed leases, that's, I think, is enough and a compelling enough reason to go challenge these leases as being unconstitutional and give people their money back, and as well as their actual ownership rights back.
Thank you very much. Thank you, Zanande. I am going to try and use some discretion here. Mary DeHaas has a comment and a thumbs up. I hope that, Mary, you're saying I can skip this as a question and give others a chance. We don't have too much time, but it's a comment that I'm sure everybody can read. It's on the published section, same as the next one from Anonymous. So I would rather go to the third, which seems to be a direct question. This one is from Nolundi. The next one is from Manketsi Klape. I'll read both and then throw them to the panelists. Nolundi's question says, what do the panelists see as the necessary steps for further moving the needle and building on the judgment? That's the one. How do you move the needle? Manketsi says, considering all the challenges of land ownership in South Africa, which are now compounded by this court judgment, do you think Parliament should continue to support existence of this institution? Right, let's go back to Nolundis then for a start, or whichever way you want. Anybody who wants to start with any of the two, let me put it that way. Denzel? Yes.
Am I still on mute?
No, you're not. Denzel, I think she's going to answer first. Thanks.
Yeah.
Okay.
Yeah.
Can you hear me now?
Yeah, okay.
So I was going to say that the institution of traditional leadership is actually an institution that is recognized in the Constitution. And in order to do away with that, that would require a constitutional amendment. Now, I don't think that is where we should be going. Where we should be going is to ensure that that citizens themselves and inhabitants of those areas are given the autonomy to make decisions on their land. And the institution of traditional leadership remains an important institution insofar as it is an institution that has cultural values, but that should not be mistaken as an institution that should own land. That's an institution really that makes sure that the cultural values are progressed, are protected. It's not akin to traditional leadership. The traditional leadership system has never, even pre-colonially, entitled traditional leaders to as owners of land. That has never happened before. And in fact, some will even argue that traditional leadership on its own was an imposition by the colonial structures. That the traditional leadership system as we have it, or as we understand it today, has been bedeviled and has morphed into something that artificially divided Black people into tribes and into lineages and lines which were colonial constructs. So that's where I think I will stop, and maybe Zenande will take the other question. Thank you.
Thank you. I don't have anything to add on that first question, but I think, it's really difficult to say. It's really easy to say, oh, we need to do something more with this judgment and actually use it to move things forward. But it's very difficult then to actually be able to really articulate how to properly do that. And I think one of the ways that needs to really happen is one, educating people about these rights and educating people about the content of these judgments and how they protect people's rights and how they're sort of aimed at moving things forward, and then really capacitating and sort of building movements from communities to push these judgments and to push for changes, which many communities are already doing, and just need sort of the type of support from institutions like us, institutions like civil society institutions that are more established and that do have access to resources to really help push forward their own sort of taking ownership of these judgments and these findings in these judgments, for us to be able to actually get some change and to get some influence. Because as Sisbulelo was saying, right now we're stuck with a situation where only our courts are operating and really functional, and we need sort of people and movement from community organizations and community organizing to strengthen and hold accountable the other arms of government. We can't just leave them to not do anything because we're like, okay, we're going to go litigate. We need to make sure that once we do litigate and get these really strong judgments, there is a parliament and there is an executive to actually move these things forward and to also take up the work itself and proactively protect these rights without having to resort to litigation. Thanks.
Thank you. Thank you very much. Thank you. And I notice former President Motlanthe is back with us. Thank you.
Yes.
We hope you will be able to get into the act. I'm not quite sure how much time we have, but I shall read the next two questions because I hope at least to get an airing of them in front of the panel and also any other members of our group. There is one from Mbumsen Teles, which is directed at Bulelwa because it starts with the word Bulelwa, comma. Do you think the judgment will do the trick of disabusing lawmakers of the notion of rural residents as tribes, in inverted commas, who hold rights communally? Is this a turning point, and will see legislation begin to go in a different direction? That's Mbongisene's question. In fact, I do believe that Bulelwa touched a little on this and probably would like to again. But the next one is Kwezi. Ukwezi uthi, I think we have to explore the political economy question in land tenure debates. The state and mining companies often present the case anchored around developing communities. This speaks to the class interests of traditional authorities. Do we understand these class or commercial interests? And can we provide alternative development models that are not based on extractive land use? Bulelwa, maybe you should kick off.
Yes, I'm happy to tackle the first one, which says, what are the, could this signal a direction for Parliament and the executive to begin to start legislating for, against this dichotomous communal versus individual. I think that the movement has started. I think that tenure reform as a mechanism, I would hope that this is something that the ministry is taking up very seriously. And the case, as I said, the KZN judgment is just one aspect of it. We have a national, this brings about a national question of tenure reform that is necessary. So I would hope and trust that that is what is definitely going to happen. And on Kwesi's question, I think that's such an important question. I will answer the question by giving a snapshot of one of the chapters that we deal with in the book that speaks to, for example, the mining regulation legislation that seeks to compensate land occupiers, but in doing so, the focus is always on almost always on patrimonial, the patrimonial or tangible meaning of land that does not go into the multiple meanings of land that go into spiritual meaning, cultural meaning. Take for example the practice of when a child is born, the umbilical cord being planted under the ground. How do you then begin to compensate for cultural, social, spiritual things like that outside of the prism of markets, of your usual markets issues. So there is another thing that the powers that be, Parliament, the executive, must begin to look at. And this is what the book Land in South Africa calls for, to say there are multiple meanings to land and why people attach themselves to land. And in compensating or even in valuing what that means and how much that should be measured, we need to understand all these multiple meanings, sense of belonging, identity, feeling part of the country. And I suspect, without making myself a politician, far from it, I suspect that there is the discontent that the country is seized with, that is sparked either by xenophobic attacks or people supporting Zuma or whatever. At the end of the day, there is a general discontent in our population because we have excluded the majority and we have not heard the majority and a stake that they have in nation building, in belonging as part of the South African identity, precisely because we have not delved deeper and looked at what those meanings and what land means metaphorically to people's states, to our people's dignity and sense of worth.
Thank you for that. Thank you very much, Denzel. Thank you for that. Can I take as President, former President Motlanthe, who you've just come in, say you've had at least these two questions. Any thoughts?
Well, thanks, Prof, and my apology for dropping off. I'm of the same generation as you are in terms of these gadgets, smart gadgets. No, I was going to say, I think if we take this process sequentially, the high-level panel's recommendations were in terms of how to secure tenure. We looked at the situation of farm labor tenants and said, they are vulnerable whenever ownership of the commercial farms change hands, they get evicted willy-nilly, and that therefore through their sweat they earn the right to live and occupy the land where they work, and that right should be secured in legislation, so that it should no longer be easy for owners to evict them. Then there's the category of the urbanites, where land hunger finds expression in the form of demand for housing. That also needs to be addressed. Then there's the rural people who live in areas that have not been surveyed and properly demarcated. So their rights also, and you know, we thought GPS technology could be used to record their rights, and that they should, such recorded rights should then be secured in legislation, so that they don't continue to be vulnerable to the abuses of those in authority. And so these would take different forms. In the urban areas, for instance, township dwellers who've been paying rent for generations, the areas have been surveyed and demarcated. They can be issued with title deeds, and title deeds are a commercial instrument. So in the rural communities where the land has not been properly surveyed and demarcated, there should be legislative protection and recognition of those rights. So I'm saying there could be different forms of you know, how we recognize ownership in legislation.
Thank you, Zenande.
This is a layman speaking.
Zenande, you look eager to go. Please.
I think I mean, I don't really have much more to add. I think both President Motlanthe and Sibulelwa really went through a lot of but I think what I want to really touch on is really the importance that Mbongiseni was talking about, of the importance of the sort of need for the legislative arm of government and the executive to come together with the courts in understanding how rights exist in communal land, or in traditional land and in traditional communities, because you have sort of this this trend where judicial judgments, like the one that we're talking about today, as well as the Kolobeni one and the Maladu judgment, and then the Richtersval judgment, and so many judgments where judges really engage with the nature and try to understand how these rights exist and how best to protect them, and how to essentially achieve the constitutional imperative of undoing the injustices that were bestowed upon these rights. And you have Parliament legislating as if none of this is happening, as if there is none of these judgments are being handed down, that the high-level panel doesn't exist, report doesn't exist, that the presidential panel report doesn't exist, and really doesn't. It has so many of these instruments at its disposal to really point the issues that have that are prevalent in their attempts at regulating this area, but they don't seem to be listening. So I mean, I don't know. I'm hoping that that sort of these continued judgments and these continued reports and these continued writings and continued pressure from communities is such that that the state will sort of listen and be like, well, this approach that we've been taking, which is to continue to entrench pre-democratic colonial and constitutional, pre-democratic colonial and apartheid approaches to understanding rights, that Black people hold on their land isn't what we should be doing anymore, and that we have ample people. I mean, rural people themselves, there are millions of people that live in terms of these systems that the government refuses to listen to. There are millions of people who can give them the tools that they need to actually move away from this understanding that is informed by apartheid and colonial regimes. So I mean, I hope that there's this change, because there's so many tools at the state's disposal, at Parliament and the executive's disposal, to really rectify a lot of what's going on. And really the beginning and the point of departure should be listening to the people that actually live in terms of these laws, and have them inform how best to deal with the systems that they themselves develop every day, for them to ensure that you don't have the sort of divergent approach, leaving people vulnerable, and sort of relying on litigation that takes years and years, and piecemeal jurisprudence for them to be able to get any type of protection for their rights.
Thank you. Thank you. Thank you, Zenande. I'm going to take a chance, Denzel, and read Mary De Haas's comment as the last thing we do. I am pretty certain that I am failing to not overstep the time mark. But let us end with this. Mary says people with rights to land face an insurmountable problem in exercising them. When a mining company manages to persuade some of their neighbors to sell their land in return for jobs, usually an empty promise. And when the majority do not want to sell, they are blamed by the mine for blocking jobs for people, which is nonsense, as very few jobs are ever created. And then those who have sold land or agreed to move turn on those who do not want to sell, usually in collusion with traditional leaders, with police tending to bow to traditional leaders. We want a clear policy from government about how they are going to protect communities like this, often on fertile land, to stop them being killed, and to bring other forms of development, creating more jobs. Incidentally, the minister also opposed a court action in 2005 to have the trust declared unconstitutional, as it was already clear that they had no interest in protecting the rights of individuals. At the risk of bringing a religious element where it doesn't belong, amen to that. I think we should stop. I have a feeling that some of these lights that are blinking are telling me we should have done this 10 minutes ago. And so my last word is thank you. Thank you. Thank you very much. This was wonderful. And thank you for everybody who attended. I declare us adjourned. Thank you.
Thank you, Prof.
Thank you so much.
Thank you, Bleloa. Thank you.